Hey everybody, News Now Wyoming bringing you another episode. This time it's going to be just a little bit more fun. It is not often I talk about auditors or the stuff they do. I just don't care. I mean, some do good, some are horrible. It's all just drama queens, and so I typically try to stay away from First Amendment auditors, unless just something happens that makes me pay attention. And in this case, this guy, whose name is Legalize Drugs, he's this big famous rapper. Yeah, right. But he does have a YouTube channel a heck of a lot larger than mine, and he is a First Amendment auditor. And so yeah, most of the stuff he does looks stupid to me. That's my own opinion, not a fact. But so here we go. We're going to listen to a little bit of his live stream from today or yesterday about a lawsuit he filed against another YouTuber, Schrodinger's cat. And then he's going to talk, in this clip, he's going to be talking about another lawsuit he wants to bring against Schrodinger's cat. So here we go. I really need to be careful with his videos. Throughout this entire live stream that he did, he was playing his crappy rap music, and again, that's crappy in my opinion. So there we go. I'm going to try to avoid playing even just a second of it because it's just that horrible. You can look at his channel by searching for Legalize Drugs and listen to his music if you want. But there we go. Let's see what he has to say. What we just ignored is one of his people said, hey, you should create a template for us to be able to file these lawsuits. And he says, oh yeah, that's a great idea. I should do that. We'll look at the lawsuit to see if he should do that, in our own opinion. I think he's a freaking idiot.
Video that he posted of me getting arrested out front of a courthouse. The video was on my channel. Me and my sister were arrested. Okay, I can't talk about the case anymore. I can't expound on the case. I'm not gonna do that. I can't do it. But we got arrested, and I'm trying to figure out a good way to say this. Part of the damages that I claimed in my complaint were that the deputies went to the Freelance Star and told the local newspaper that we had been arrested. Now, it turned out to be a false arrest. So once someone publishes someone's false arrest or speaks on it, that's defamation. So Schrodinger's cat made a video not only stealing my music. The video ultimately got taken down by YouTube because it was in violation of copyright law for my song. Not only did he steal my music and put my music in there, he told everybody he posted the video to his channel, and the video was of me getting arrested. It was a false arrest. So he posted a false arrest that led to the same thing that he did is the same thing that I already received damages for in a separate case. You understand what I'm saying? So you can't announce that someone's been arrested if you don't know that the arrest was lawful. You can't do that. You can't.
Sorry. I was trying not to interrupt him. Show me the case law on that. To me, it's always back to show me the case law. I did do some digging here. Virginia's got some standards on defamation. Their republication of what happens if you publish something that was said by somebody else. That's pretty. Their rules on that are rather loose and not really defined. The Federal Court of Appeals, including the 2nd, the 8th, 11th, which I'll admit Virginia is not part of either of those three, but they've all said that If all you do is report that somebody was arrested, then that's just reporting on the news, and to try to stifle that does more harm than good. So you can report on an arrest no matter what the outcome of that arrest is. In some of our Circuit Court of Appeals, I could not find any case law on it in the Fourth Court of Appeals. If anybody does know of any, please let me know. I would love to see it. And then the Supreme Court has refused to hear anything to the has refused to hear any cases about it, because the circuit courts that have ruled on it, circuit courts of appeals that have ruled on it, have said that no, this is stupid, you can't sue for that. So there could be a case in the state, and then the question would become, could you appeal that to the Court of Appeals, and what would the Court of Appeals say? Again, very questionable, but he's saying this as if this is 100% true, which it is not. Okay, I can't find very many case law. I can find no case law to support his position of it, and very little case law arguing against it. So, again, if anybody does know of anything, let me know. But I can report on you being arrested all day long. I can choose whether or not to report on you being released. Yeah. Is that defamation to report on the fact that you were arrested? No, it is not. That is a fact. In truth, in any state of the U.S. is a defense to defamation lawsuits. If all I say is you were arrested, no matter how it turns out, that is still a fact.
Because basically what Schrodinger's cat did was this. The police defamed me. Okay? The police defamed me. Schrodinger's cat...
Oh, and he did say this was already settled in another case. Their court records, I'm having a hard time accessing their local court records there. Federal lawsuits, I can't find crap on this guy. So, again, if anybody has documents or anything to show how I am wrong, please. But he said that this has already been settled with the other newspaper. If this was settled with the newspaper and somebody's got that, please show me. I would love to read it. I would love to see that. And if that happens, if somebody provides actual legitimate documents, I will follow this up with another video of here's how I was wrong. And so there we go. Yeah, this was already settled in another case. Prove that.
Went and repeated to his audience the narrative of the police officers in my arrest video. That's defamation. Because if what they did and said was defamation, what Schrodinger's cat did and said was defamation, because he said the same thing they said, that I was arrested for disorderly conduct.
If you were arrested for disorderly conduct, you were arrested for disorderly conduct. No matter what the outcome of the case is, that is still a fact. Does not make it defamation.
You can't say that.
Yes, you
That's
can.
defamation. It turned out that arrest was a false arrest. I was found not guilty. I sued. And that's that.
You sued where? Again, there may be some federal filings here, and I'm just not finding it. Sometimes PACER is really difficult. Maybe it's in a court, the state court there, which Virginia state courts records are even worse than PACER is. So yeah, isn't it? Yeah, and I hate unlawful arrest. Come on, let's face it. What do I talk about the most? Unlawful arrest. That's what all of my channel is about, right? Or most of my channel is talking about lawsuits against the cops for bad behaviors. And so if there is a federal case or anything that goes anywhere, I would love to cover it. if I can find it.
You can't.
You can. All right. So we are going to look over at the. This is just one. Okay. This is just. There's lots of sites that talk about defamation law and all that stuff. In Virginia, the elements of a defamation claim are publication of an actionable statement with and the requisite fault on the part of the defendant. To be actionable, the statement must be a false statement of fact that harms a plaintiff's reputation and community or deters other persons from associating with them or her. These elements of a defamation claim in Virginia are similar to the elements discussed in the general defamation law section with the following exceptions. Defamation per se. Some statements constitute defamation per se. These statements are so horrible they will always be considered defamatory and are assumed to harm the plaintiff's reputation. So, number one, attributes to the plaintiff commission of some criminal offense involving moral turpitude for which the party of the charge is true may be indicted and punished. So, let's take a look at what moral fortitude. Okay, so here it is. One definition. Every state looks like may define this differently, but a phrase that describes wicked, deviant behavior constituting an immoral, unethical, or unjust departure from ordinary social standards such that it would shock a community. Criminal law, the law sorts criminal activities into categories of crime either involving or not involving moral turpitude. The phrase moral turpitude itself has not been clearly delineated by courts, owing in part to amorphous relative and various conceptions of morality. Courts, however, such as Zimmerman, have commonly quoted the following in order to describe conduct that involves moral turpitude: an act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow men or to society in general, contrary to the accepted and customary rule of right and duty between man and man. So, this is a crime, such as a somebody who likes taking photos of children in awkward positions. That would be a crime that would be shocking to society. Murder, shocking to society. Those types of things. Is getting arrested for trespass, which is what the lawsuit is about. Is that moral turpitude? Hell no. Is disorderly conduct charge moral turpitude? No. But he argues that it is defamation per se because it is so horrible that it's just so obvious. Which is just not true. Nothing else in here for per se would fall into so public and private figures here. What constitutes a public figure? Would a YouTube person fall under a public figure? And with the way that this guy in the lawsuit actually talks himself up, I would argue that he is a private figure, and that matters because a private figure, it crosses states, and here in Virginia is no different. It becomes a higher bar to prove maliciousness. Than some random dude on the street. If I were to go out there and say that homeless guy is nothing but a bum who has never worked a day in his life. Okay, and I said that about a specific person. That's not a person of public figure, right? But if I were to say something against this dumbass with 20,000 subscribers and again, in the lawsuit, he talks about how awesome and amazing he is, how many things he's done for the public. I would argue in his own lawsuit, he puts himself up there to that public figure status. And so here, but they look at the following factors to determine whether a plaintiff is a limited purpose public figure. Did he have access to channels of effective communication? 20,000 subscribers. Yes. Did he voluntarily assume a role of special prominence in a public controversy? Yes. He sought to influence the resolution or outcome of the controversy? Maybe not. But probably existed prior to, and he retained public figure status at the time of the alleged defamation. So, here it talks about public officials, all-purpose public figures, and limited-purpose public figures must prove that the defendant acted with actual malice, knowing that the statements were false or recklessly disregarding their falsity. So, if you are a public official or what did it say, a special use public figure, then they actually have to prove that actual malice. Actual malice is a lot harder than just substantial danger. Yeah. So, Virginia courts, fair report privilege. Precise scope of the fair report privilege is not clear because all of the cases interpreting it have involved reports of court proceedings. The privilege report covers reports of court proceedings, including matters stated in court documents when the report is made in good faith and substantially accurate. And then a few federal courts interpreting Virginia law have applied the fair report privilege to governmental actions, like the unofficial public remarks of a member of Congress and official letter of reprimand leaked to the press. So, neutral reportage is not. They have not identified any cases in Virginia concerning the neutral reportage privilege. And then wire service, yeah. So fair report privilege. Again, that's what I was talking about at the beginning. It isn't really clear. Alright, but let's go ahead and let's skip all this and let's go into the lawsuit itself. Because this is hilarious. Alright. Mark Stout v. Cliff Overby. You gotta post a photo of yourself. If you are a pro se plaintiff, it's just required. Alright, this is by law. No, it's not, you guys. This is stupid. Why would you post a photo of yourself? Mark Stout, a.k.a. Legalize Drugs, is a resident of Fredericksburg, Virginia. And then Cliff Overby, Schrodinger's cat, is a resident of Portsmouth, Virginia. Jurisdiction in venue. This is where, of course, in lawsuits, why they talk about jurisdiction, or where you prove why this is the correct place to be heard. This court has jurisdiction because this action for defamation is being brought within 1 year after the cause of action accrued. Mark Stout's claim for recovery against Cliff Overby is in the amount of $200,000. Cliff Overby defamed Mark Stout. That is not... Oh, you know what? Let's do this. Can I change the color of this? Okay, so this would be relevant, right? And not relevant. You know what? No, let's... Okay. You know what? Let's do this. Okay, you're not going to let me do it? Alright. Okay, so yes. Alright, so we're going to do that. Okay, so this is relevant. This is not relevant to jurisdiction. He is principally employed in Portsmouth, Virginia. Okay. Mark Stout's cause of action against Cliff Overby arose in Portsmouth, Virginia. Okay. You know what? I will remove that. I could see that being relevant, so we'll go ahead and remove that. Okay. Facts. Mark Stout's YouTube channel. In August 2019, Mark Stout created a YouTube channel and named it after his rap artist stage name, Legalize Drugs. His YouTube channel features his music. This would be under okay. It also features videos of police encounters, mostly encounters between police and Mark Stout. He is a civil rights activist, camera person, and cop watcher, and frequently films the police and police-citizen encounters. Naturally, if Mark Stout films police-citizen encounters, Mark Stout frequently captures police misconduct and constitutional rights violations committed by the police. Yes, naturally, that is such a that is so clear that is exactly what happens. Videos featured on his YouTube channel show the police frequently violating individuals' rights, including his own clearly established constitutional rights. Again, I'm not watching his crap. He plays his music in every single one of them, and why would I subject myself to that horribleness? Constitutional rights violations captured in the videos featured on his YouTube channels have been the grounds for federal civil rights lawsuits that have resulted in financial settlements and non-disclosure agreements. You know what? Hold on. Okay, we're just going to take a look here. This is the, I believe I went into the Eastern District of West Virginia, which is the federal district that covers his area. So you look at this first one, Mark Stout, and you pull up that docket. It was filed, prisoner civil rights. Ooh, was he a prisoner? I don't know if he was a prisoner, but it was dismissed for failure to pay the filing fee. But it was the Middle River Regional Jail. Okay. Look at this one, Middle River Regional Jail. It was terminated, dismissing case that he has the right to appeal this decision if he has so. Oh, you know what? Memorandum opinions. Let's go ahead and find out why the judge. Court conditionally docketed the action, advised plaintiffs that they must keep the court advised of their current address. So this one was dismissed for failure to keep his address up to date. Okay, thank you. Wait, hold on. Oh no, I did it. Hold on. Okay, I apologize. I accidentally closed it. So let's look at his third one here. Oh, 09, complaint against him, prisoner's civil rights, and it was dismissed without prejudice. Yeah. Okay. Fourth. Ooh. Fun. Okay, so this could be, I don't know, Stout et al. Let's find out what this is. Mark Stout, Robert Stout. Motion to this action is dismissed. So let's actually see what is in here. This time let's not close out of Firefox. By filing a complaint in this court, which set forth the following allegations. The court accepts all facts contained in this complaint as true, and plaintiff's complaint is a form complaint for violation of civil rights. Plaintiffs maintain that defendants have violated their First Amendment right to freedom of expression, freedom of the press, and freedom of assembly. Plaintiffs also claim that defendants have violated their 14th Amendment right to equal protection and due process. They violated the First and 14th Amendments to the Constitution when they acted under their authority as city police officers to enforce Virginia's trespassing laws. Plaintiffs contend that the actions giving rise to their claims occurred on December 17, 2019 when they were present on the police department's public sidewalk. Plaintiffs allege that they stood right outside, but on the publicly accessible side of the security gate that separates the publicly accessible area of the parking lot from the restricted area that houses police vehicles and police equipment. They specify that they were standing there to capture a police officer on camera and flex their constitutional rights. While standing on the sidewalk, plaintiffs saw defendants get out of their vehicles, then open the security gate, step through the publicly accessible side of the gate, and stood a few feet away from the plaintiffs. He was not detaining, but their encounter was consensual. At some point thereafter, one of the plaintiffs began speaking with and filming another lieutenant. Dug one hand into R. Stout's back, gripped R. Stout's tricep. Plaintiffs maintained that at this point, Sergeant Michaud told plaintiffs that they were being trespassed and escorted off the property. Plaintiffs further claimed that at one point, one of his hands left R. Stout to push M. Stout off the property. Both parties have requested the court review plaintiffs' videos of this incident, and the video does not depict either of the officers making physical contact with the plaintiffs. Plaintiffs contend that Sergeant Michaud told them that the police department parking lot was his public property, that Sergeant Michaud did not need a reason to trespass plaintiffs, that he could trespass anytime he wanted to for no reason at all from a public property. They also allege that when they were escorted off the police department property, it was the first time doing this. Okay? Plaintiffs recall that Lieutenant Bisek observed the entire incident, and that plaintiffs aver that in this situation, Bisek supervised Michaud as the department's designated official placed in charge of officer training. So they're going to, this is a 12B6, should be granted unless an adequately stated claim is supported by showing any set of facts consistent with the allegations in this complaint. A pleading that offers labels and conclusions or a formulaic recitation of the elements of a cause of actions will not do. Complaint is also insufficient if it relies upon naked assertions devoid of further factual enhancement. So to survive a Rule 12b6, a complaint must set forth a claim of relief that is plausible on its face. Okay. Defendants move to dismiss plaintiff's complaint for lack of subject matter jurisdiction and for failure to state a claim. And while defendants maintain that lack of subject matter jurisdiction is an appropriate basis for dismissal, at its core, defendants' arguments concerning subject matter jurisdiction is essentially that plaintiffs have failed to state a plausible claim. Nevertheless, the court observes that plaintiffs have chosen not to complete the portion of their form complaint that required them to specify their basis for subject matter jurisdiction. Plaintiffs chose not to check either option, and plaintiffs do not specifically state the basis for this court's subject matter jurisdiction anywhere else in their complaint. Despite this glaring omission, the court recognizes plaintiff's pro se status, and based on the facts contained in the complaint, the court infers that plaintiffs have brought the suit under 1983. So they did that on their own. So to be sure, this court does have subject matter jurisdiction to consider a 1983 court claim. Yet dismissal is nevertheless appropriate in the instant case because plaintiff's complaint lacks a sufficient factual basis to infer a plausible 1983 claim. Yeah, so there we go. Dismissed because it was just wrong on so many levels, right? Let's look at this one. So this was just a screw up, okay? Now let's go to this one. Complain about this. This is the same one which we already looked at. Date terminated, so this was already dismissed. Okay. If this is actually the correct Mark Stout, I don't know. I'm just trying to figure out what he said. Further questions. So far, This one is Mark Stout and his father again against the Sheriff's Department. Finds the plaintiffs unable to pay the cost of proceeding in this case. Accordingly, the court grants the plaintiff's motions. The court directs the clerk to docket the complaint and to issue a summons upon the defendant. The court directs the U.S. Marshals to serve the defendant with the summons and a copy of the complaint. And so here, 825. I think I'm going to save this one here. Give me a second and I'll... Okay, so I've marked this one as to read and figure out what's going on with it. Timothy Baruti, city manager. So this is another federal question here. So there's a amended complaint here, and then summons. Yeah. Okay. So he does have a couple lawsuits out there pending. So yeah, these are newer cases. Good, good. I don't know if Mark J is the same person. Again, I can't verify that any of these are the same person, right? It was terminated. It was transferred to the Richmond Division. Okay, so this one was transferred to somebody else, but this is against Harris in his first sergeant individual capacity and against the Sheriff's Department itself. Again, file 2020, civil rights questions, Stout versus Harris and Spotsylvania. Yep, so this is also transferred over, okay. This looks like another one against Harris. So they have responded, so I think I'm going to go ahead and I'm going to actually save these ones as well. Okay, so... terminated 2008. So dismissing case without prejudice. Granting motion to dismiss. So I can't find any that were dismissed because of a settlement or any confidential stuff, unless that Richmond one. Again, I've got to look into that Richmond one a little bit. Why was it transferred to a different court? I'm not sure. I'm not taking the time right now to look at that. My gosh, we haven't even looked at most of the lawsuit, and it's already 30 minutes in. So we are going to end part one here. I wanted to just go through these. I shouldn't have done this. But he made a statement, and I wanted to find out more about it. So there we go, you guys. What you think, let me know. If you've got more information on this YouTube channel, Legalize Drugs, definitely let me know. If there's any other case law I should be looking at, definitely let me know. I want to hear from you, and let me know anything else. Have a great day.